Hello, everyone. Sue Pete here. We are here today with Charles B. Ticker, estate mediator and litigator, and we're here to discuss an interesting topic. Charles, is mediation a stressful experience for the participants? Yes or no?
Well, there's no question that clients or siblings that are involved in an estate fight that are told that we have a mediation scheduled next week typically are coming to the mediation with quite a bit of stress. First of all, if they're most likely involved in litigation that's going on for some time, which is in it itself creates a lot of stress. This is new uncharted waters for them. They don't know what to expect. So I do often have to spend quite a bit of time just making sure everybody is comfortable. And we stress that at the beginning of every mediation. We want everybody to be comfortable and try to lower that stress level, because it's very difficult to negotiate if you're coping with a lot of stress.
Well, I imagine, how would you compare it to litigation in terms of stress?
Well, it's part of the litigation process. So it may be it's not as stressful as being in front of a judge in a courtroom and being cross-examined under oath. But what I often tell the clients, because they're not stress-free at the mediation, it's just say, you think this is stressful. If you don't try and do your best to settle the case today, just wait. You'll see what stress really is when you're in front of a judge who doesn't really have the time of day to really hear about your whole family history, is just interested about the facts and the law, and doesn't really want to deal with your problem. And that's going to be stressful. So I use that to, in a way to say, like, there are different levels of stress. Mediation is stressful, but it's much more stressful down the road if you don't settle.
And would the level of stress at a mediation depend on the mediator or the circumstances or the lawyers, or like what does that depend on, the level of stress that the participants experience at mediation?
Well, certainly the mediator's role is to lower the temperature, lower the emotion, because otherwise it's going to be very difficult to get a resolution in these disputes, which are very emotional. The lawyers also have a role to play. And I've seen this, unfortunately, where lawyers think that they're advocating like they would be arguing in court. And that's not the purpose of mediation. You're there to encourage settlement, yes, to protect your client's interests, but lawyers have a professional duty to encourage settlement and try and reach a settlement for their clients if appropriate. So sometimes I have to take lawyers aside and say, look, it would be helpful if you sort of didn't egg your client on in this respect. And I often, well, not often, I always tell the clients, I say, today is your day. I want to hear from you. I don't want to hear from your lawyers. And I said, lawyers, you may not like to hear that, but today it's the client's day. So I try to focus on the clients, particularly where you have a lawyer who may be getting in the way of, helpful negotiations.
All right, so should mediators meet privately with individual clients, individual participants in the mediation prior to booking the mediator or prior to the mediation? Have you ever had a request like that?
I did recently, and it was the first time. I've certainly have spoken with counsel prior to being retained as a mediator, because we have to talk about conflicts, if there's any conflicts, or maybe they want to know my approach. But I recently had a request where the clients wanted to meet with me or and check me out, so to speak, before deciding whether or not to retain me as a mediator. And I sort of was hesitant at first, and I said, well, okay, I'll do it. But what I learned from the exercise, or from the experience, is what was really going on here is that these clients were so stressed and they were so concerned about what the mediator would think about them and how he or she would judge them. That's what they were trying to get a feel for. So I think what I took away from it is mediation is stressful for the clients. They don't really understand the role of a mediator. We're not judges, we're neutrals. And it's up to their counsel to try and explain to them that, look, this is how the mediation is going to work, and this is the role of the mediator. But it just underscored the level of stress that clients go through when they're thinking about mediation.
So would you do it again? Would you meet with individual clients prior to being hired for a mediation?
Well, I'm hoping, I think maybe just refer them to, like, which I have done, is just refer them to some of these videos, or this one in particular that we're doing today, and say that you can check me out and see my style and see what I'm like. But
I'm
no,
hearing that as
so
a
would I
probably
do it
not.
again? You never say never, but it's certainly not something that I would say would be part of my everyday practice as a mediator. But it
And
is a
if you did
common.
it, you would do it with both sides, right? Not just
Well, in this case, I did do it both sides of it separately, but because they wouldn't want to be on the same call together. But I think what I typically do is that if I have a call with the lawyers together, and look, I understand that this is a significant investment for clients, and they want to make sure that they get a mediator that they can work with, and that's when lawyers are discussing who should be the mediator. Everyone sort of has experiences with mediators they work with, and sometimes they're open to trying someone new. Sometimes they're reluctant, so they may want to speak with that mediator. So I understand that, but and so that's the reason I might do is just so the lawyers may want to understand how I would approach a case, or and that sort of thing. But it's not, as a rule of thumb, it's not something I would do. No.
So just to end it today, how should lawyers prepare their clients for mediation so that it becomes a less stressful experience for the participant?
Well, and that's key, preparation. And I think if I've seen cases, if lawyers do not adequately prepare their clients, the clients come into the mediation with totally unrealistic expectations. They think they're going to get everything that they want. And like I always tell clients, like Mick Jagger and the Rolling Stones sing, you can't always get what you want. So they have to manage expectations, and they have to explain that mediation is not a trial. The mediator is not a judge. The mediator is there to help the parties make their own deal or settlement, and understand that mediation, although it's part of the adversarial process, it should not be an adversarial experience. It's a time to sit down, and yes, you have to have tough negotiations, and there's nothing wrong with pointing out the weaknesses or strengths of each side's case, but you have to do it with the temperatures at a lower level, and you're not there to sell your case to the mediator. You're there to try and help your client get out of a very stressful situation and put the experience behind them and get on with their lives.
I lied before I said it was the last question, but this is the last question. Is your role as a mediator to bang heads together to come to a solution, or to make sure that the parties are feeling heard?
Sometimes you feel like you really want to bang heads together because it can be very frustrating. Look, my approach, and different mediators have different approaches. My approach is to really work hard in building trust. And sometimes lawyers get a little annoyed with me saying, like, you just cut to the chase. But to me, it's very important to spend the time to listen to the client, find out where they're coming from, what the family history is, and then hopefully get some idea of what's driving the dispute, and hopefully get them to the point where they can resolve the dispute with their sibling. Having said that, and I'll tell the clients and their lawyers this at the beginning. If later in the day I feel that a settlement maybe is within reach and people are getting bogged down on something they shouldn't be bogged down in, I may weigh in with my opinion for what it's worth, saying I think you may want to consider this. But you got to be, in my view, you got to be very careful how you do that, because if you do it too early in the day, you're going to turn off the party.
It sounds like you place a big emphasis on the parties being heard. Yes.
It's all about the parties. It's all about the clients of mediation. That's my view.
Okay. All right. Well, we've been here today with Charles B. Ticker, estate mediator and litigator. Charles, thank you very much.
My pleasure.